you marry a non-Ghanaian, you can't go beyond 50. You're also limited to 50.
Very well.
So those are the clarifications that are made in the land. If a Ghanaian marries...
What does the Land Act 2020 say about land acquisition for non-citizens?
So you are looking at Section 10.
I've seen a number of people do land searches themselves and they end up misinterpreting.
The
so you can do the search.
Yes, but the contents.
Yes, because of your misinterpretation of the search result, you end up doing a
wrong
mistake.
decision.
For instance, even this was a professional, it was a surveyor.
Yes.
He did a land search and then half of the land was not ready. He was like, "Oh, madam, where do you free land though?" I said, Ghana has, I see me here free. I was like, "Oh no, it's free," because in the report it was like the Lands Commission usually in your terms would say it's not affected by any
recorded transaction.
Yes. I said, "Oh, madam, where do you free?" I say, someone says that if I have a sub-lease and I can't locate the sub-lessor, should I renew the lease with the original lessor?
So this is a tricky one because a sub-lessor, by its understanding,
can landowners repossess your land if it's not developed within a certain time frame? What does the law say about this?
Yes, so if you find, as we've indicated,
can someone buy a farmland and decide
to change his mind?
I want to do estate on the land now.
Yes.
In the second part of our interview with the Lands Commission boss, you will get to know of all the critical insights as a landowner in Ghana. In the past weeks, my team and I have had to deal with several cases of land purchases gone wrong in Ghana. And of course, it tells of the lens to which we need to carry the conversation regarding land acquisition in Ghana. And so we are back here again. And for those of you who've reached out to do your land searches, great job. A step at a time, we hope to make land purchase in Ghana a lot more safer. And so my name is Efia Fosuayo, a trusted real estate consultant with Harmony Havens Real Estate Group, where we help you build generational wealth through real estate. And so let's get into the office and you'll definitely get to know more. Come with me. Hello, sir. You're welcome again.
Thank you very much.
We are happy to be here, part of the conversation.
Now we call ourselves family.
Yes, certainly.
So as I indicated, you'll be a consultant too.
Oh, thank you. Very well. So this conversation is going to center primarily on some of the follow-up questions we've had from our initial conversation. Let me remind you, or let me note that we've in time past had several interviews regarding land acquisition with Mr. Timothy Anyedohu. So this isn't the fourth interview. This isn't our first interview. We've had 3 previous interviews. So I would advise you to go back and watch all of them just so you'll be able to make informed decisions. I have a question from a viewer.
Yes.
And the person says, can landowners repossess your land if it's not developed within a certain time frame? What does the law say about this?
Yes, so if you find, as we've indicated earlier on, every indenture is a contract.
Very well.
With clauses in them. Most indentures, most agreements, most documents you see would have certain clauses in them. One of the clauses that you see is a development clause, which says you should develop the land within a period of, say, 2 years.
Okay.
So it is a clause, because it's a condition or it's a clause in a contract, the grantor, which is the person who is giving it to you, can sue on that.
Okay.
So if you want to look at the law, then what you can do is what we call re-entry. And section 57 to 60 of the Land Act 1036, it prescribes a certain procedure for re-entry. So yes, the question is yes, only that the law says that if the breach is remediable, meaning that the person has to give notice to you that, look, your 2 years has passed, you've not developed it, and give you a reasonable time to remedy that breach. If you don't remedy the breach, then he can seek to go to court as a condition of re-entry.
Oh, so that's a powerful clause.
That's a powerful clause. Most people don't pay attention to that, and also it's an advice. If you're a landowner, you can't just jump onto. It's not like you are waiting. As soon as it's 2 years, you jump onto the land and go and repossess it. The court is not too much minded to encourage.
Okay.
So what you need to do is first give the person a notice. We give him reasonable time to breach it, to remedy the breach. If he doesn't remedy the breach, then you can institute procedures for re-entry.
Very well,
Yes, please.
very well. Second question, if you buy land from a chief or a stew that isn't registered with the Lands Commission, where do you obtain your indenture?
So the indentures or documents are always obtained from the person who is giving it to you.
Okay.
Because he is reciting to you how he got the land,
Okay.
the conditions, what we call the recitals, and why, or the conditions at which he's giving it to you. And sometimes you see questions like this because in some parts of the country, particularly the northern region, the Lands Commission assists in the procedures of helping stools prepare documentation. But that is not even Lands Commissions. If it's not state land, the Lands Commission is giving to you. In some places, there's arrangements where you get your what they call allocation notes. You go once there's a confirmation that it was from this chief. Then Lands Commission helps the stool with the drafting of a certain documentation, but it is still executed by the stool or the family, and then they submit it for registration. So just as part of the responsibilities of Lands Commission to assist various land owning groups to be able to administer their land, we can assist in helping. Some people come even for what you call the initial draft.
Okay.
But you know, all these documents have to be endorsed by a solicitor as a lawyer, so they should be produced by a lawyer of the stool. Lands Commission may help you with the arrangements of it, but ultimately it must be endorsed by a solicitor, so some solicitor must own the documentation.
I remember in one of our earlier interviews you mentioned, and now the status or government is asking for stools or family heirs to register
yes, to
their
register.
lands.
That is the provision inside the Section 182 of the Land Act 1036.
Okay.
So it encourages all the landowners to register their first documentation, and it's also that it will be easier when you do searches to find out. Also helps because when you want to register, you have to go through a processes of sorting out your boundaries with your neighbors and all that. So that registration process would help maybe resolve some lingering issues and help before the documentation is put in the records of the Lands Commission.
So the responsibility lies on the family heirs and
then the stools, yes, to that registration. But primarily it is their responsibility. Because I own something.
Very well.
What do? I need to register it. So do we, those of us who buy property. It's our responsibility because we want our interest to reflect in the record, public records. Otherwise, if you don't get your interest to reflect in the records, if somebody else does a search, your name doesn't appear, and the person who sells to you is a dishonest in quote, or goes to sell to another person, then he becomes an innocent purchaser.
And that's where double sales
would happen.
comes in.
Yes, please.
Okay, so I have a question on lease renewal.
Yes, please.
Someone says that if I have a sublease and I can't locate the sublessor, should I renew the lease with the original lessor?
So this is a tricky one because a sublessor, by its understanding, your interest is less than your sublessee, your interest is lesser than your sublessor. So for instance, I give you 10 years. Then you gave our good friend there 8 years. So you still hold your 2 years that the reversion. So there are two ways. People wait out for the entire lease, even of their grantor, to expire. When it expires, then they go back to the original grantor and say that, look, this person gave me a sublease. I'm sitting in the property. My lease has expired. I'm looking for him. I can't find him. So I'm coming back back to the original grantor, because the original grantor, who does he know? He knows your sublessor.
Very well.
That's the one he contracted with.
Very
he gave you a lesser interest than what he has. So if his interest hasn't expired, it's very difficult to skip him and go straight to the grantor. So when his interest expires absolutely, and the grantor has made reasonable these things and cannot find him, he may then be in a position to now deal directly with the sublessor.
So I think one thing that people are still not very clear on has to do with leases renewal. For some people, they think that, if I have a land at airport, for instance, and presently a plot is selling at, say, $1 million, or its equivalent in the Ghanaian cedis, it means that when I have to renew, I have to pay
the same same
amount.
No,
please clear that bit.
So when it comes to renewals, there are two ways you can go about them. One is what we call a surrender and renewal, meaning that you don't wait for your entire interest to expire. So you have 50 years instead with 5 years. Then you go back and say, look, I'm at this position, I'm ready to surrender the 5 years for an extension for 50 years. At that time, you are negotiating with the 5 years that you hold. So the negotiation involves valuation mathematics that gives you more in terms of, and you pay less to your landlord. It secures the interest. The second one is when you wait for the lease to expire altogether.
Very well.
Then you are going to your landlord and say you should renew. If you look at the provisions in the Land Act again, Section 50, it spells out certain conditions for renewal. So, for instance, if you are an indigent and you are in that same area, it says you renew with customary drinks, for instance. So, if you are not an indigent, you're a citizen, and then you're given land, then it just says you renew. The difficulty is that it has to be at a reasonable price.
Very well.
What a reasonable price is, as I always say, is what the courts will begin to determine as time goes on, because a reasonable price is done by some valuation. So real estate valuation and estate surveyors, who we call the valuers, are the ones who assist in determining that price. But in my practice, you never get it to be the open market price as it is now. It's not something that you will come to. You come to a reasonable price, but not the open market price.
Very well.
And that's what happens in most cases. Yes.
Okay. So now let's move the conversation on to land search, the very big one.
Yes.
Now, I've seen a number of people do land searches themselves and they end up misinterpreting.
The
so you can do the search,
yes, but the contents.
Yes, because of your misinterpretation of the search result, you end up doing a
wrong
mistake.
decision.
For instance, even this was a professional, it was a surveyor.
Yes.
He did a land search and then half of the land was not registered. And he was like, oh, madam, where do you free land though? I said, hey, Ghana has, I see here free. I was like, oh no, it's free because in the report it was like the Lands Commission usually in your terms would say it's not affected by any
recorded transaction.
Yes. I said, oh madam, where do you free? I say, hey, no, it's not free land. Please, what are some of the risks you could be exposing yourself to when you do the search, yet you even misinterpret the search results? Okay,
so from the question that you asked, I want to set a few examples of what may lead people to misinterpretation. So you may have, it's not state land. Then they'll say it's not affected by any recorded transaction. So that's the word recorded transaction means that nobody has come into public records and asked us to register it. So that doesn't mean the land doesn't have an owner.
Very well. It's not free land.
It's not free land.
There's no free land
we
in
said,
Ghana.
It's not free land.
Very well.
So that should be, so people should not misinterpret that as meaning the land doesn't have any owner. That is why we say additional checks on the ground where the land is purchased from will let you know who is the regularly administers land in that area. And that may be able to help you determine the owner. If we follow what the provision in Act, Section 182 of the Act that says everybody should register their LODIA, then we'll get to a time where we have less of such information because everybody would have registered this past. That's why it's important to encourage people, because it may open also your land to people claiming to administer the land when they don't have the authority to do so. That's a risk that you run. Also, people in Accra, in other parts of Ghana, we give you one search, and it's from the records of the Lands Commission. In Greater Accra, we give you what we call the consolidated search, which has information from 3 of our divisions, and it has a historical antecedent. We were all different institutions and were merged in 2008. So everybody keeps a little bit of record. So until 2021 October, 2021 October, we used to give you separate information, but we know that it was also misleading people. People were choosing which forum to go for their search. So now we stopped that. So now we are into our 3rd year now where we consolidate the search. We give you every information we have on that parcel of land in the records of the Lands Commission. So you may find that there may be something in, we say PVLM, which is Public Invested Land Management Division records. You will have something from the Survey and Mapping Division, and then you have something from the Land Registration Division. Ultimately, the land title certificate. It's what is the ultimate proof of title in this country. So if you do a search and you read all and then you just see at the end that somebody has a land title certificate, please be guided that that is the person you must be dealing with.
Very well. Yes.
That should be the person you should be dealing with ordinarily, except that certificate was defective. But if it's not defective and it's not being cancelled in our records, your primary source of consideration should be a land title. Assuming the person doesn't have a land title certificate, but you see from the record, it is government land, government gave it to you, then you know that the records are flowing through in a particular way. So he may not have a land title certificate, but you can see from the narrative that they said government acquired the land, then they said government gave it to Mr. X. So that gives you some comfort. You may also see that the survey and mapping division has some what they call plotted activity. It's just an indicative record of people who may have requested for a plan or people who doing the process of title registration. The plan is being prepared for them. That doesn't mean that in all cases it may accumulate in the land title certificate. So it's part of the process. So it may happen that at the end of the process it may not be granted.
Very well.
Very well. So people, when you see the survey and mapping record, don't hold on to it like it's a sacrosanct record. It may be indicative of somebody going through a process of registration, but it doesn't mean that that person has ultimately obtained, or all those who have their records as survey and mapping would have their. It all sounds funny, but when you get the research report, you break it down. You see that we've tried to break it down under the various headings, so that people can just generally be advised about where this information is coming from, where that ultimately the commission's records will be merged and cleaned. We are not there yet, where we will now be comparing certificates to parcel and then say, okay, maybe we think that this record is the only record, but we are not there yet. At the moment, we are duty bound to disclose everything that we have on the parcel to help.
Very well. But it still goes without saying that at least to a larger extent, the land search helps.
Oh, it is.
It saves you.
In fact, it is the most indicative way, because you come to register, wouldn't you, after you finish it? So if there's something in that record that would be a detriment or be a hold up to your registration, why don't you get that information now? And as I say, we talk and say, oh, not everybody has registered, but largely, especially in the urban areas, people have made efforts at registration. So you always have something in the records of the Lands Commission that may assist. People, I just spoke to a friend of mine who is a lawyer also, who is trying to do some due diligence, and said, oh, he just went to the courts to do a search on the name of the family, just to know whether there's any litigation. And then I said, oh, that's our classroom due diligence that is reflecting. So anything that you can do, that's why we always say tread slowly, tread softly, and make all the inquiries you can make before you give up that money that you have. Yes.
Do the search before you pay. Yes. Don't go and pay before you do the search. And there's one very critical step you never want to skip anytime you want to buy land or any other form of real estate in Ghana, and that's for you to do your due diligence work very well. And one means to doing this is through a thorough land search. Of course, you can always reach out to our company, Harmony Havens Real Estate Group, to have us assist you with your land search. Reach out to us on www.harmonyhavens.com, harmonyhavensrealty.com, or you can find our details in the description box below, and we will definitely assist you. Now let's get back into the video. So I want us to go through some of the results or outcomes that I have seen from some searches and what they mean. I've seen outcomes relating to encumbrances. What do they explain to us?
What the word
very
encumbrance?
Terms, yes.
No, yes, encumbrances is it's like something holding, something which is indicative on the parcel, but it doesn't mean that the parcel has been traveled. So, for instance, let me set an example. A mortgage is an encumbrance.
Well.
So it's not, doesn't mean that when you go to money from the bank, you've transferred your interest to the bank. But it just shows that you have taken money against that property.
Okay.
So that if anybody wants to buy, then you have in your mind that there's a debt on there's a debt on that property.
Yeah.
So encumbrances, it may be just be people litigating. For instance, a man, Mr. Something left property for his children, and then his children are now trying to sort out whether the will is correct or whether, then they write to us and say, look, place this on record, that at the moment they have not come to transfer ownership. They are just putting that, there's an encumbrance, there's something that has held that property. And it doesn't mean that it's been transferred, but it means that it gives notice that there's something hanging on the property. So that if you want to transact with it, you should have in your mind that this challenge is there. So encumbrances are just generally fetters, what we call fetters on the property. They are not actual transfers. It may be notice of litigation. It may be a mortgage. It may be notice of some interests. That's some overriding interest that may be under processing, for instance. So it's just good information to have in addition to the ownership.
Very well. Okay, I've also seen outcomes. I think you spoke about this briefly, but outcomes relating to long history of land disputes.
Yes.
I've seen somewhere the dispute is like from this year to this year for this family.
Yes,
then
it
it
comes
moves back.
Then, so you know that's a litigious land. So it's even giving you an idea that this one, they've been going through the motion. So maybe when they went to High Court, they came to Lands Commission. One party won. So we registered it. Then they went through processes of a Court of Appeal. Then Court of Appeal reversed the decision. Then they went to Supreme Court. Then Supreme Court reversed the decision again. So at any point in time that they litigated, they came to us. Sometimes even it may be litigation between two parties. Then a third party appears from somewhere and now litigates against both of them again. So you see long history, and you must know that that land is a land that has suffered a lot of litigation, and you must then be giving you an idea of at which stage of the court processes the judgment was. So is it a High Court? Is it a Circuit Court judgment? Is it a Court of Appeal judgment? Is it a Supreme Court, which is the ultimate? Even in the Supreme Court, is it under review or not? Because under review, the court may take a different view. That's why this famous Numomashi matter that came, the judgment that they passed, which said decision was made sometime in 1983. We worked with it all the way, but the Supreme Court has a different view today. So imagine what our records now will state in respect of those.
So in each outcome, the Lands Commission has records of what happens in the court.
That is if the litigious parties come to us. So at the moment, we don't have a direct link between our records and the court records.
I've also seen outcomes relating to zoning information.
Yes.
What's zoning information and its importance in land searches?
So zoning usually is the responsibility of the what we call the planning authority. So those who do the stop work, our friends who work with the assembly, who give the building permits, they are the ones who are responsible. So they are parent organized land use and spatial planning authority. So at the local government level, they are called the fiscal planning authority. So they are the ones who say build a house here, build a church here, build a, so for stool land in particular, which Lands Commission grants consent and concurrence to, and state land, we may have records also that cover the zoning status. So we may, as additional advice, give that to you. But there's the real authority that is responsible is the fiscal planning authority, who are the assembly level. So if you want to buy stool land, for instance, and you come to Lands Commission for a concurrence, we refer you to the assembly, to the fiscal planning, that advises on what the zoning status of the plot is. So if they come and they say the place is a marshy area, or it's not a place for playground, or it's a place for market, you may have your document, but we will not register it for you.
Because it's been
earmarked for that. Yes.
Specific.
Yes. So in the Land Act 1036, we try to bridge the gap between planning and land administration. So Section 117 says, after the passage of the law, the planning authority should give Lands Commission the layouts that they have. And as soon as they pass a layout within a period of 1 month, they should set it on us, so that now we have all our records almost matching in tandem. For stool land and state land, it has been easy, but for family land, because there is no requirement by law that we check with planning, it was possible to register, say, a road. in the
Very
past.
well.
Yes, because he has the right documentation. The owner is there's two. They have the right authority. The family have the right authority. So we go ahead and register. But in order to eliminate that, now we are trying to get or planning. And if it is what we call large scale, 4 acres and 4 hectares and above, for residential, 20 hectares and above, all those ones we are duty bound to consult the fiscal planning authority before we go ahead and register.
Okay. Can someone buy a farmland and decide
to change his mind?
I want to do estate on the land now.
Yes, so it happens quite a bit. If you look at historical antecedents, people buy land at the fringes, usually huge tracts of land, and the city just grows and then attaches to that place. Then suddenly the user changes. Now you can see residential buildings coming up. So it's a problem that arose between the grantors. Because if I give it to you for farming, suddenly the city has come up with it.
Very well.
Then I say, oh, me too, I have my documentation. So what do you do? So we had some provision in the Land Act, I think it's section 19, where now the law says that once the city catches up and the zoning changes, it gives an opportunity between the landowner and the grantor to renegotiate.
Oh, that's
because we're looking at protecting the grantor also by the time you gave it for. So there's a formula in the act that the parties would abide by. But it's all to solve problems that we've seen happening over time, where people bought 50 acres at the fringes, then they call it rural Accra or rural secondary, or then suddenly population expands 20 years later and the town has caught up with it. And the guy is still holding on and saying, I paid for it, I own it, it's mine. But come on, at the time you bought it, it was for farmland. Now the city has caught up with it. Can you now renegotiate and then cede some back to the and we've made provision in law to do so.
For that.
So that will be a point of resolution now.
Okay.
If that happens.
Okay. So it can be resolved. Very well. So I've also seen outcomes relating to government interest.
Yes.
If you could talk briefly about that.
So you find that it's every search would have to state whether the government has interest or not. So it will say not state land. If it is state land.
Is that why it's always your first?
Yes. So you are so familiar with us now.
Well.
So you find always that it has to say something.
Okay.
If it is not state, say it. If it is state, say it. So the first point is it is state land. That is it, or it is not state land. Because we want you to draw your mind to the fact that state has interest or not.
Okay.
So if state has interest, all the other grants should be flowing from the state. Okay. So once you don't see that, then you know that there may be defects. People may have attempted to register, it didn't work. People may have had, sometimes we say even state land, then you find lower down that they disclose some interest. Those interests are subject to the state's interest. That happens rarely in a few cases. But they would then have to seek compensation from state. So the state interest will be two ways. You see that it is purely state land, it will state, or it is vested land, meaning that it is vested in the state to manage on behalf of some particular traditional area. So that one also is government that must grant, only that the money that comes out of it. And that vested land, for instance, no more, by law now, is outlawed. You cannot vest more. But the old one that has vested, government is still managing that. Yes.
Okay. Yes. What key factors should people consider when buying land from the family or a stool?
It is the most major and complex part is the capacity of the person granting to you. Is the person the one who the family is the family head? Is the person who is the stool occupant? Are they acting in concert with the principal members if it's a family? Or is the principal elders who is the stool? That is very key. Very, very, very key. As we said, all the other things as in cross-checking, doing a search, checking on the ground whether it's all went up the same way. But for grants, the capacity of the person claiming to be the grantor is very, very, very important. Under the Act 1036, the creation of what they call the Customary land secretariats is going to help a great deal, we believe, where now every customary area must have what they call the Customary land secretariat. So it's like his mini lands commission. So they will be recording his grants, they will be taking record of his grants. So it makes it easy now for them to have records of what they are given.
Okay.
So that the issues of double grant and not knowing that I've given it before, or your predecessor coming and not having a full record of what you have, all those matters will begin to plug the holes.
Very well. Now, when you take a walk through town, you see a number of these secretariats.
Yes.
I've seen some in Chado,
Yes.
in Pram Pram, and in other places. So it's there to serve. Is it there to serve land buyers as well? Can I just walk in to run my checks?
So they are supposed to, yes. So if you look at the provisions in the law, it will be possible for you to do a search with them. But they are just to deal with the records of their customary land holding area.
Very well.
I agree that some people have become more than a secretariat. They've now become, I don't want to use words, but they become digging fee and land. No, that's not why they are. No, if you look at the law, and the law tries to build a regulation for them so that they don't start acting out of place.
Okay.
But the land secretariats are mainly, if you look at the objects of the law, to form as a place of recording grants from the customary land secretary, from their stools, families, clans, tendaners, so that they can have a record of what they are giving out. So the Lands Commission, they must deposit quarterly, in fact, they deposit their records with the Lands Commission. It's all to encourage them, to encourage those they are also granting to come and register.
Okay.
So that now we'll be bridging the gap of registration, because the registration gap is quite wide in Ghana. The land coverage that has been registered nationwide is not as much as we expect. The last statistic we had was 10% or so. So we want to encourage more registration. That's the only way we can have enough record to be able to deal with issues of
The other time you spoke about digitization of your registration process.
Yes.
How is that going so far?
So it's going well. It's going well because we've been able to move a few steps forward. Critically for us is your submission of documents. The slip that you receive now reports all the way to the second that you submitted it. It's very important for litigation because the time you submitted. Also, we've done some major processes of getting our records information up front very early. You know, in the past, before 2015, you submit, we request you under title registration, we request you to go and prepare a plan before we come and do our searches. But now we do the searches as soon as you submit so that we can have a full gamut of information. It has improved our publication process with the newspaper. So we have done some process, but once again, we are believing that once the right investment comes in, which we are hoping under a certain PPP arrangement, we should be able to make some strides in the digitization of our records.
Very well, very well. Okay, so what does the Land Act 2020 say about land acquisition for non-citizens?
So you are looking at Section 10. So who a non-citizen has been classified into two things.
Very well.
An individual, like Timothy,
Very well.
and who is a citizen. So if you are not a citizen of Ghana, you are one category. Then a company. What is a Ghanaian company? Because you know, companies have a separate legal entity. So those are the two categories. So for a company, if the Ghanaian's interest exceeds 60%, then it's a Ghanaian company. In the reverse, if the foreign interest is more than 40%, then the company is not a Ghanaian company.
When you say Ghanaian interest,
yes,
Ghanaian interest from where?
So a Ghanaian interest meaning that it's a Ghanaian who owns the 60% or more.
So for instance, you're American,
yes.
I'm Ghanaian.
Yes, and we are entering a partnership to do a business.
Okay.
Our shareholding structure should be such that the Ghanaian has 60% or more.
So in that sense,
for
the
land
leasehold
purchase
implications would be
that you can now get more than 50 years.
Okay.
But if you are a foreigner, maximum is 50 at one particular time. Our constitution says that in Article 266. So the Land Act just clarified. So if you marry a non-Ghanaian, you can't go beyond 50. You are also limited to 50.
Very well.
So those are the clarifications that are made in the Land Act. If a Ghanaian, Akwesi, marries Miss Chong Hu, who is a friend, is a Chinese woman, he cannot get more than 50 if they are quiet together.
Okay.
But if Akwesi comes to acquire it alone as Akwesi.
Maybe Akwesi was single then.
Yes,
when
yes.
he acquired the land.
Then that means he acquired it as a Ghanaian and it's in only Akwesi's name.
Very
and it will be
well.
Akwesi's interest.
So Akwesi will be getting his 99
or whatever. 90,
but the moment Akwesi marries
no, it doesn't. If he marries Chinchonchi and they want to own property together,
okay,
then in Akwesi and Chinchonchi, that is when the 50 years will hold him.
Very well.
Yes, but if he wants to own it as an individual and he's known to be Ghanaian, that one he's not restricted to the 50 years.
Okay, let's now talk about, again, it brings to four questions regarding land ownership in marriage.
Yes, spousal rights. Yes.
Talk to us about
yes, so I suspected where you were going because he said then he marries Akwesi. So section 38, 47, I think 97 all speak to marriage and in the Land Act 1036, and it seeks to bring a certain clarity.
Okay.
Now the law starts with a presumption. One, if Akwesi owns property and then Akwesi marries after ownership of that property,
okay,
that property is not carried into the marriage.
Very
It
well.
is still his property. But anything that Akwesi acquires after the marriage, it is presumed that both of them own it jointly. But it's a presumption. Akwesi in that document can have a certain clause that clarifies that he's buying it on his own. By conduct, it can also be, that presumption can be overthrown by a court where Akwesi married Akosia and Akosia abandoned him for years, he's not been here, he's been only 1 year.
Well.
Then the court will now have to determine whether that presumption was a presumption by the parties. So that is it. If Akwesi has a gift during his time of his marriage, the law also says that it is exempted from sharing with his spouse. So there are presumptions, there are things that would help you get out of it. But if once it was got for valuable consideration during your marriage, then there's a presumption that it's
okay. How can landowners protect their land rights from encroachment in Ghana?
Yes, so the advice I always tell people that now in Ghana, if you buy land, you must have some level of money to wall or put some presence on the land. I noticed that people find bare land easy pickings. You buy land, you put it in some place, you have done nothing really to show that there's an ownership. You are just running a risk. So I always say do something that is hardly would you see people go and break somebody's wall, because so do something significant. As I say, showing presence by the law principles, a gravel of sand, some mango trees, all of them can show presence. But from a practical point of view, I'm telling you, whatever you can do that can secure that property, please do so. People just put one caretaker somewhere there, one building caretaker. Do something that would help any reasonable person who wants to buy that land, who they want to deceive. He comes something like, there's a small building, then how did they get here? Or there's a wall here. It gives a certain sense that somebody else has interest in the property.
Now, the issue of landguardism, how does the Land Act 2020 address that?
So it's a section 12 of the Act. Once again, provision was made. Even if, in fact, if you look at the provision, it doesn't even talk about landguardism. All it says is protection of interest. So the Act saw that there was a challenge because there are those who finance, those who instigate, then there's the final man who is the macho one. So the law looks at all those in the line, those who procure them, those who is financing them, and the macho man himself as possible people for prosecution. So if you prosecute and then you find them guilty, the law makes provision for prison terms of between 5 and 10 years. And I've recently read some court matter. I was just flipping through the news where somebody who was a self-styled chief somewhere sold the land that somebody had the right documentation over, and I think destroyed a few things, and the court jailed him for a number under this act.
So it's working.
It's working. Yes. So and I've known about a few cases where prosecutors have come here and we've drawn their attention to the fact that look, they can go under this act rather than under the old system of going under misdemeanors and all. And they've taken it as good advice and they've gone ahead. Once the education is going, they are coming to know. Then they have ways by which they can deal with the way that yes.
So I have a question from a viewer. He says that he bought the land and he bought it from the chief.
Yes.
And he tried registering, but the registration didn't go through. And the report he received from the Lands Commission, the feedback was that someone had acquired a title over the land.
Yes.
What are the possibilities?
So his challenge is that, and once again, I'm sure if he did a search before the purchase, maybe this title would have shown, albeit it has happened already. I asked, are you in possession of that same plot, parcel of land? If you're in possession of it, and for instance, you found out that there's a title of it, it's likely your grantor may say, I didn't give anything to the person.
Okay.
So it is you instituting some action against that person for some proof of title, because you also believe that you got it. If you can get the court to declare that his title is invalid, then fine. But if your grantor is the one who gave it to him, or
in
his
this
predecessor,
case, the person said the grantor is saying, no, I haven't given.
so
how
how
is that even possible?
So how, because Lands Commission can also only register what was been given to somebody by somebody.
The grantor has
so
to.
the grantor, in fact, I will be having an angry grantor seeking to pursue the person who did it. So Lands Commission, give me any record so that I can institute an action against that person. But you find out that the person rather turns his anger against the commission rather than the purported person who registered, because it's like having a shirt and the shirt is mine and I've sending it to you. Then somebody comes, snatches the shirt and says, oh, it is mine. I said, I didn't give it to him, so why should he have it? So I should be angry to be chasing that shirt and saying, please take your shirt that I've sold with you. But strangely, you may find out that the person is content just to know the grantor didn't sell it. He's content. And the grantor is also saying, I didn't sell it. It's possible that even the grantor's predecessor may have sold it, because mind you, if it's family, it is in perpetual succession. So I may be a family head today, I may sell today, the other person may not know. He comes, he see the land, he thinks it's bare, he also sells
it.
Then so he may say it's true, he didn't sell, but did his predecessor sell? That's the question that you must ask.
And one thing can solve all of
this.
this.
Yes, if he had done the search in the beginning.
See,
he would.
Mr. Timothy Anidoho, I can feel the stress people. I understand the stress people go through when you have to go to court to fight over a land. When in fact
you could have prevented this. Yes,
one step. Prevented all of this.
One step, and everywhere I have gone to, the first question I ask everybody: so I have documents, so I've not registered them. When I ask, oh, when you're buying it, did you do a search the first step and say no? Then it's a recipe for disaster. So you may be lucky. Some people have come, especially those who got their land from states, quasi-states like TDC, State House, and some organized structures. You may not have this problem so much, but we all know that record keeping among the family sense too sometimes are not as sharp. Hopefully, the Customary Land Secretariats can help resolve this, and then the section 182 that says the registration should be done.
Okay, very well. And we are wrapping up on the conversation, but I would want you to wrap it up for us. Speak to our people, please.
So first of all, we are grateful for once again a follow-up. I've not met a host that is as passionate about ensuring that people have an understanding of something, and they say learning is to learn and learn again.
Very well.
So every day we have a conversation. I believe it's an opportunity for people to learn. For me, I always say the diligence we use to buy every other thing, a car, dry clothes, tomatoes, fish in the market, is the same diligence we must use to buy land. And when the landowners find out that people are being more diligent in doing their searches before committing money to them, they will also now begin to consider registering their interests.
Very well.
Yes, but what happens is that most people are too eager to part with money because of another guys that, oh, it will get finished or the land will not be available. But please, just ensure that you have the search. You can't ask to buy land and the person tells you, finish paying before I show you the site plan. How then do you know whether that land is state land, not state land, for the person selling it? So the site plan should be the first thing that you must wish to engage if you want to buy land. And that becomes the basis of your search. That at least gives you some good information.
Very well.
Then you check on the ground also, the neighboring, and it will give you, if there's conflict there, you will know. If there's no conflict, you will know. And never buy a land under the assumption that it will just be available to take. Please don't.
Another observation that I have made has to do with the fact that people go buying land, and then the moment they are buying from a real estate company, they are confident it's safe. Please talk to us about that.
So what really is the deception is that real estate companies may, some of them, and not all of them, may have walled the place. And then they would have pillared the place. So when you come and you enter a certain wall, your assumption is that all documentation-wise is done. But that is not the case. Your example that some examples that you set may lead people into problems. For instance, there's a real estate company. They go and see some traditional authority and they start some negotiations towards buying land. And because of the size of the land, they may not be able to pay all the money at once. So they are staggering payments with the traditional authority, but their documentation is not ready yet. So he's marketing and selling.
I've seen this before.
Yes, and then people go, you also buying. You don't ask the real estate company, give me a site plan or something that I can also run a search. Your assumption is that everything is fine. The risk even is when they give you long period of payment, that you get your documentation after 5 years or 7 years.
I have seen those ones.
Yes. So by the 7th year when you go, that company even may not exist.
Very well.
That real estate company may not exist. Even if it exists, when they give you the documentation and it's not registrable, what do you do? Because you would have invested money in buying already. So like I tell everybody, even if it's your father who is promising you that he will give you land, just get a surveyor to do the site plan for you, or you to get your site plan and run your search. It gives you an understanding of what you are getting yourself into. For instance, if the real estate is able to show you evidence that they are entering a transaction with Nana or Say, and you do a search and Nana or Say himself has registered his interest, it gives you some comfort that they are already in a certain relationship with that tool. And if you want to do further checks, you could at least look for them even just to confirm that, are you entering a transaction with this person, and then you pick it up from there. But please, people should not assume that every real estate company has the right documentation.
Do not assume.
That is wrong.
Trust but verify.
Yes.
Do your checks and everything is going to be okay. Yes. Very well. Mr. Timothy Anyoduku, thank you so much.
It's a pleasure.
For taking time off your busy schedule to talk to us again.
Yes.
This is the 4th video we have done. Please take time to watch all the videos. We have spent a lot of time in making these videos just so you're able to make informed decisions. Please subscribe to the YouTube channel and do let us know your thoughts as well. Please trust but verify. Very well. So here's where we wrap up. My name is Efia Fosua and we'll see you in our next video.